Please be seated. The sitting is resumed, and I now give the floor to Mr. Robert Kolb. Please go ahead.
Madam President, distinguished members of the Court, I have the task of presenting the arguments of the Government of Myanmar on its third preliminary objection. It concerns the reservation the state has entered to Article 8 of the Convention Against Genocide. This text defines the scope of the subject matter jurisdiction of the present case. Before proceeding with the legal analysis, it seems advisable to me to say a few words in favor of a balanced and cautious approach. We are being asked here to consider technical aspects with regard to preliminary objections, and we need to address this issue in a dispassionate manner. The third objection relative to the reservation is in the alternative to the second objection on having standing to take action should the court uphold the second objection, it will not be necessary to consider the current one. The reverse is also true. If the court upholds the present objection, it will not be obliged to consider the second one. Let us take a brief look at Article 8 of the Convention Against Genocide and the reservation in question. Article 8 of the Convention states that, and I quote, "Any contracting party may call upon the competent organs of the United States to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any of the other acts enumerated in Article 3. End of quote. In the original text in English, the reservation to Article 8 reads as follows. With reference to Article 8, the Union of Burma makes the reservation that the said article shall not apply to the Union. The first question to be raised is to understand if Article 8 covers all the organs of the United Nations. This means including the court. The court is qualified by Article 7, paragraph 1 of the Charter as principal organ of the organization. Article 92 of the Charter designates it as principal judicial organ. These provisions prove beyond doubt that Article 8 should be understood as including the court. The texts are clear. They are unambiguous and they are without anomaly or anfractuosity. They suggest no restriction, no impediment, and no mitigation. You can see for yourself. It says, competent body of the United Nations Organization. Where is there even the slightest limitation? The travaux préparatoires confirm this inclusive interpretation. despite certain proposals to restrict Article 8 to the Security Council and the Assembly General alone, that is to say, to the political organs, the final text mentions indiscriminately all organs of the United Nations. The choice, therefore, is very clear and indisputable. The order of provisional measures in the 1993 genocide case leaves us with an open question. It states, and I quote, "The court considers Article 8, even assuming it to be applicable to court as one of the competent organs of the United Nations," etc., unquote, unquote. Why? Well, I see two reasons for this. The first reason is as follows. The court should not take a stand unnecessarily on a matter of law put to it for the first time at the pre-preliminary stage of provisional measures without the advantage of adversarial proceedings. The second reason is that the only issue at stake in this order was to decide if Article 8 conferred additional powers to the court with respect to its status. The court dismissed it. One does not need to go any further. In short, this precedent does not contradict the interpretation of Article 8, which is very clear in its wording. What about the other references to your jurisprudence? Our learned colleagues make a point of stating two passages. First of all, in the order indicating provisional measures in the present case, you have stated that Article 8 and Article 9 can be regarded as having distinct scopes. Only Article 9 of the Convention is relevant concerning the question of the season of the court in the present case. This assertion only has the value of an initial approximation in this order. This issue of the relation between Article 8 and Article 9 was not resolved, and therefore it warrants more in-depth analysis, and I will come back to it later on. Furthermore, in the genocide case of 2007, the court stated that Article 8 concerns the prevention and repression of genocide at the political level and is not, therefore, related to legal responsibility, which is understandable. In that case, the court was called upon for legal reasons pursuant to Article 9. There was no reservation applicable, and hence Article 8 could not contribute further to the legal procedure. Its scope was limited to the political procedures that the other organs of the United Nations could provide. Our opponents point out that the words of Article 8 to take such action as they consider appropriate argue against the inclusion of the court in the organs referred to in this provision. These words would refer to discretion in action, and the court would not have such discretion, and thus your court cannot be considered to be included in Article 8. Maybe, but nothing obliges us to have such an interpretation. The clear text of the provision refers without restriction to the organs of the United Nations. The court is one of them. It is not up to you to include limitations that are absent in the text. It would be tantamount to revising the text and not interpreting it. Given this very clear and unequivocal inclusivity, the words mentioned above must be understood as referring specifically to numerous political bodies that it is possible to call upon. On the contrary, these words normally are not intended to extend to the court. Well, it is precisely because Article 8 refers to both political and judicial bodies that the broad and all-encompassing language can be justified. It allows us to cover both procedures and avoids making an already long sentence even longer by adding lexical inclusions. Furthermore, the words "take such actions as they consider appropriate" can very easily apply to the court. You have the authority to take provisional measures proprio motu. They depend on your assessment, and one can say that you use a form of discretion. I suppose that one would retort, well, why doesn't Article 8 specify what the court is supposed to do in the case of a seisin, just like it does for the political organs? The answer is, it is not necessary to take a stand on this point. The jurisdiction of the court is governed by Article 9. There is no need, therefore, to say more in Article 8. It is just a question of logic. Our opponents argue, in the same vein, that the English text of Article 8 contains the term "call upon," and that it is inappropriate to use this term for the court's action because one doesn't call upon the court. I would provide the same answer to this argument as the previous one, but I would add that the French text of Article 8, which is also an official text, uses the word in French saisir. What does that demonstrate? That no decisive argument can possibly be drawn from the English words used. Our opponents further add that the terms, quote-unquote, competent organs of the United Nations Organization were used in a series of other treaties when referring exclusively to political organs. That may be the case. But look at the examples that they provide. The context of these provisions shows very clearly, most often, that only the political organs are referred to. For example, the Commission on Human Rights has the power to ask for information from the United Nations bodies that are in charge of administration of territories under their supervision or non-autonomous territories. Can we seriously make a parallel with Article 8 of the Convention on Genocide? I don't think so. This text is deliberately inclusive and not exclusive, and this is a major difference. What is the relation between Articles 8 and 9 of the Convention? Is the session of the court governed exclusively by Article 9, or does Article 8 play a role in the matter? Can Article 8 have an influence on Article 9? That is the key question, and that will decide the fate of the third preliminary objection. Myanmar believes that Article 8 and Article 9 are twins, that both are relevant to the court. that the first concerns the Sazin and the second article concerns the subject matter jurisdiction of the court. It is acknowledged that Sazin and jurisdiction are two distinct notions. The former is a procedural condition. Without it, there would be no proceedings. The latter is a condition for the court to be able to rule on the merits of a conflict. Without it, the proceedings cannot go further. If there is no Sazin, the proceedings simply don't exist. In the case of absence of jurisdiction, the proceedings are hampered. Why does Article 8 concern Sazin? First of all, because its text so suggests. It asserts that all contracting parties can seize the competent organs of the United Nations. It is true that, unlike the French text, the English text doesn't use the word. It is, however, used in other official versions, for instance, in the Spanish version. Therefore, we cannot conclude that the expression saisir in French was used randomly or even inadvertently or rashly.
Furthermore, it's because the logic of the text supposes it. If this provision does not concern Sazin, it would become superfluous. Would it be necessary to suggest that bodies of the United Nations or organs of the United Nations could deal with questions involving genocides? For this purpose, the provisions contained in the Charter were sufficient. I'm sure that you will agree that the added value would not go beyond a simple reminder. On the contrary, if this provision referred to Sazin, you couldn't say that it was redundant. It could form a lex specialis on the subject, at least as far as the 1948 Convention is concerned. But then why should one not mention specifically what the conditions for Sazin are in Article 8? I would give the answer that because the conditions vary for each organ of the United Nations. As that's the case, it would have been rather unwise to try to specify them. That's particularly true as these conditions might have developed over time in bodies and texts outside of the 1948 Convention. Could one risk saying that Sazin is not regulated by Article 8 or Article 9 of the Convention, that it's governed rather by the sole statute of the Court and the general rules of international public law? A reservation to Article 8 would therefore not prevent the Sazin of the Court, because it would only cover Article 8, rather than the other provisions which refer to Sazin. This kind of interpretation would run up against the same effects of the same considerations of a legal effect that I have just sketched out. If the court could be seized despite these rules outside of Article 8, what would be the effect of the reservation? The effect would be a fantasy. It would be inexistent. It would be null and void. A great deal of care is taken with one voice to say that seizing should be excluded, whilst admitting in another voice that seizing would remain possible. So, as well as stripping reservations from their legal effect, this interpretation would end up postulating a contradiction, and for this reason it is fitting for the court to reject it. Article 9, as for it, is a compromissory clause of jurisdiction. The function of this clause is to give jurisdiction on questions of interpretation or convention, application of the convention in which it is inserted. Ordinarily, it would be absurd to assume that the compromissory clause guarantees the jurisdiction of the court, but does not allow seisin. The usefulness of such a clause would be reduced to nothing. And that way, the court normally includes the ability to seize the court. But does that deal with our question? I don't think so. These other conventions do not have equivalent provisions to Article 8. Under these conditions, it is normal to attach to the compromissory clause both the right of seisin and the right of jurisdiction. But when a special provision on seisin is inserted into the text, it is essential to apply it, because to act otherwise would be to betray the wish of the parties and the logic of the text. By the presence of Article 8, Article 9 is limited to its principal function of giving jurisdiction and stripped of its nature governing seisin. For these reasons, Article 9 does not reduce the freedom granted to the processes of the court. It shares it with Article 8. Article 9 refers to jurisdiction, Article 8 to seisin. According to Myanmar, another distinction is essential. Article 9 originally limited the jurisdiction of the court to those disputes between injured parties, injured states, within the meaning of the ILC on state responsibility. On the contrary, this provision did not devote jurisdiction of the court to those disputes with a non-injured state in the meaning of these same articles. This is the case of states working on an erga omnes partes basis without having suffered a violation of their own rights and interests. Now, Myanmar advances as proof the wording of the compromissory clause. Unlike the Article 24 of the European Convention of Human Rights, adopted at the same time, Article 9 does not claim that the court has jurisdiction for any dispute between any of the parties contracting to this convention. The difference is not a purely chance one. If one examines it carefully, the wording in the 1948 Convention falls within the general framework of general law at the time. Now, one might object that the current interpretation of Article 9 is fixed, and that these days it's understood to have extended jurisdiction of the courts to disputes erga omnes partes. But the court has affirmed in the Belgium versus Senegal case of 2012 that the Convention on Torture of 1984 and the Convention on Genocide of 1948 are similar, and has recognized the ability of Belgium to bring a case before the court in the context of the 1984 Convention. Does that settle our question? Well, not necessarily. In Myanmar's view, the seisin under the 1948 Convention is governed by the lex specialis of Article 8. What does this amount to? Well, in our current proceedings, there is an applicable reservation which is to exclude the ability of the Gambia to validly seize the court. Whether the court has jurisdiction or whether it does not have jurisdiction on the basis of Article 9 in its current wording, it cannot be validly seized because of the reservation under Article 8. Myanmar doesn't advance the fact that its reservation excludes any seizing of the court under Article 8. On the contrary, it feels that the text of its reservation covers only the interference by third parties, third states, interpreted into the wish of the reserving state and the aim pursued. It only refuses or rejects those applications brought before the court by non-injured states within the meaning of the term given by the ILC. In other words, this reservation under Article 8 is not to strip of all meaning Article 9. An injured party or an injured state can seize the court and the court can enjoy jurisdiction. Reservations are unilateral acts. In their interpretation, the wish of the reserving state must have a more important role than for bilateral or multilateral agreements. Even more so, it must have a dominant, indeed decisive, role to play. Your court has recognized this in the case of the fishery jurisdiction case, Spain versus Canada in 1998. It has claimed that one would have to duly take into account the intention of the state concerned at the time when it accepted the compulsory jurisdiction of the court, and has added that what is required in the first place for a reservation to a declaration made under Article 36, paragraph 2 of the statute is that it should be interpreted in a manner compatible with the effect sought by the reserving state. There's no real difference in the context between a reservation under paragraph 2 or paragraph 1 of Article 36 of the statute, between a reservation worded in terms of an optional declaration or a compromissory clause. Now, I'm not saying that a unilateral wish should always be determinative, but I don't see why it should not be given credence in the present case. And why not give it credence? Well, because Myanmar is not searching to try and extend the scope of its reservation by reducing the scope of jurisdiction of the court. On the contrary, it is trying to contain the scope of its reservation by increasing, by reflection, the scope of jurisdiction of the court. I would be surprised if this were not welcomed and that Myanmar were not taken at its word. What would be the alternative? To give a more robust effect to its reservation? I find that hard to believe. Perhaps one might object that in 1948 the distinction that was drawn between injured states and non-injured states was not current, and that Myanmar could not have had it in mind when it worded its reservation. Well, Burma formulated its reservation a few years after the advisory opinion of the court on the Genocide Convention in 1951. So the special nature of this text was therefore known to it. Now, you'll perhaps say that I was too quick to react, that I've supposed that the reservation was applicable without explaining to you why. Now, so that you shouldn't think any bad things about me, let us take a closer look at it. I'd like to remind you that the reservation, which is applicable in the current proceedings, excludes Article 8 from being applied to Myanmar. The reservation aims in practice to set aside the ability of non-injured states to unilaterally seize any organ of the United Nations concerning allegations of genocide. In other words, it's trying to protect Myanmar from interference by third parties on these questions. Now, is this reservation valid? Is it flawed by subjective or objective defects? Is it weakened by the disputes located between the parties or by shortcomings in international law or objective law? To look at the subjective level, it's a question of the relationship between the parties in the current case. It refers to the existence or non-existence of objections to a reservation. And in the current case, we cannot determine whether or to what extent other contracting parties have objected to this reservation. One thing is decisive. The Gambia has never objected to it. Absent any objection, it has accepted the validity and applicability of the reservation on it. As a result, the reservation should be applied to it according to its wording and its aim. Let us turn towards the objective level. Is this kind of reservation permissible? Does it run up against provisions of either treaty law or international general law? In the case of armed activities of 2006, the court ruled that reservation of reserving jurisdiction under Article 9 of the Convention Against Genocide was permitted. I draw the conclusion that it must be possible to limit the access to the court to the injured states alone by excluding non-injured states. After all, if you can move mountains, you can move molehills. The result, therefore, is that this reservation does not run counter to the object and aim of this convention. Under Article 19, letter C of the Vienna Convention of the Law of Treaties of 1969, this famous criteria is advanced. It reflects customary international law. I notice that the 1948 Convention does not include any measure on reservations and therefore does not forbid them. Such is the meaning of Article 19, letter A of the Vienna Convention of 1969. It also reflects customary international law. The Court has recognized that reservations can be applied to the 1948 Convention in its famous advisory opinion of 1951 about the reservations to the Convention for the Prevention and Punishment of the Crime of Genocide. From the above, one should conclude that the reservation of Myanmar is applicable. The Gambia has not objected to it, and no obstacle exists in treaty law or general law to oppose its validity. Well, if this kind of reservation is applicable, then the seizing of the court via Article 8 of the Convention is excluded. The reservation blocks all access to this. The argument of Myanmar under its third preliminary objection is that the court has not been validly seized and that therefore it does not enjoy jurisdiction. The reservation by Myanmar to Article 8 of the 1948 Convention is a hindrance to it. I would therefore like to close my presentation for today and thank the court for its kind attention. And, Madam President, if I could ask you to be so kind as to call to the bar Mr. Christopher Staker.
Back to Mr. Staker.
Madam President, Mr. Vice President, members of the court, Myanmar's fourth preliminary objection is that the court lacks jurisdiction or that the application is inadmissible, as there was no dispute between the Gambia and Myanmar when the application instituting proceedings was submitted. It is, of course, well established that the court cannot exercise its contentious jurisdiction unless the dispute already existed between the parties before proceedings were instituted. The Gambia accepts that this requirement applies in this case like any other. The Gambia has also not disputed that the burden is on the applicant to establish the existence of the prior dispute. The issue for your decision is whether the Gambia has discharged that burden in this case. Myanmar says it has not. In explaining why, I will first deal with the requirements that must be met for a prior dispute to exist. I will then address the circumstances of this case. Madam President, members of the court, I turn then first to the requirements. At the outset, a point of agreement is noted. Both parties accept that the existence of a prior dispute is a question of substance, not of form or procedure. This means that no specific formalities need to be observed for a dispute to exist. But this conversely also means that no specific formalities will necessarily suffice. All will depend on the particular circumstances of the individual case viewed objectively. These circumstances must, however, satisfy four requirements. The first is that the prior dispute must be the same dispute between the same parties as that submitted in the application instituting proceedings. The second is that the prior dispute must be a legal dispute. Obviously, the court can only decide legal disputes. If the prior dispute must be the same dispute as that contained in the application, then it too must be a legal dispute. This means, for instance, that prior exchanges of a political nature will not suffice. These first two requirements are the very essence of the prior dispute requirement. The Gambia does not expressly challenge their existence. It does, however, dispute the next two requirements. The third requirement is that both parties must have been aware of the other's position. It is self-evident that if two parties hold contradictory opinions, but neither knows of the other's views, there is no dispute between them. A dispute only arises when their views are made known to each other. As Judge Owada has said, It is the objective awareness of the parties that transforms a disagreement into a legal dispute. In the rite of passage case, the court thus asked whether events had led the parties to adopt clearly defined legal positions as against each other. The Gambia claims that this third requirement would allow a respondent, simply by remaining silent, to prevent the applicant from knowing the respondent's position, thereby preventing a dispute from existing and precluding litigation before this court. That is not the effect of this requirement. If the applicant has made a legal claim that calls for a response, and any reasonable time to respond has passed, then the applicant may well be aware of the respondent's position from its silence. However, one way or the other, each party must be aware of the opposing view of the other. Contrary to what the Gambia seems to suggest, the court has never said otherwise. In the Marshall Islands case, having found that the respondent was not aware of the applicant's position, the court did not need to go on to decide whether the applicant had awareness of the respondent's position. However, the court said that a dispute might be inferred from the respondent's silence, thus affirming that the applicant does also have to be aware, from the respondent's silence or otherwise, of the latter's position. If this third requirement did not exist, the effect would be this: the applicant could present a claim to the respondent in a note verbal and then institute proceedings an hour later. The prior dispute requirement would be met because just prior to the application, the respondent would have known of the applicant's claim, and the applicant would not need to know the respondent's position. If that was correct, the prior dispute requirement would be a pure formality. What purpose would it serve? It serves no purpose unless it allows both parties to articulate their legal positions to each other before a case is brought. The judicial settlement of international disputes is an alternative to the direct and friendly settlement of disputes between the parties. Obviously, friendly settlement is only possible once each party is aware of the other's position. And until they are, there can be no dispute in respect of which a friendly settlement could be reached. The court would be burdened with many unnecessary cases if judicial proceedings could be brought before there is even a dispute capable of friendly settlement. I move on then to the fourth requirement, which is this: the parties' prior legal positions must have been articulated with a minimum degree of particularity. The need for this requirement is illustrated by this hypothetical example. Suppose that State A said to State B, quote, "You are in breach of international law," unquote. Suppose it's unclear from the statement or its context what conduct of State B is referred to or what rule of international law is said to be breached. Suppose State B responds simply that it's unaware of any breach of international law on its part. Suppose State A then brings proceedings against State B before this court, and its application now specifies the impugned conduct of State B and the norms of international law said to have been violated. Can it be said in this example that the prior dispute requirement is satisfied? The answer must be no. In this example, there was in form a prior allegation by State A of a breach of international law which State B did not accept. But there was no prior dispute in substance. It cannot be shown that the prior statement of State A was referring to the same matter as that submitted to the court in the application. Indeed, the prior statement of State A was so lacking in particularity that it could not be known what legal claim it was making, or whether it was even making a legal claim at all, rather than a political statement. If State B could not know what claim State A was making, then State B's response could hardly be a positive opposition to any claim. Contrary to what the Gambia suggests, Myanmar does not contend that the applicant must fully develop its factual and legal claims before it seizes the court. Rather, it's only a minimum degree of particularity that is required. What is that minimum degree? Essentially, the positions of the parties have to be stated with enough particularity to make it possible to determine that the first three requirements I've referred to are satisfied. In cases where the dispute is said to be manifested by the respondent's silence to a claim made by the applicant, then of course it's the applicant's claim that has to be examined. Is it stated with sufficient particularity to establish that it is indeed a legal claim rather than, say, a political statement, and to establish that it has the same subject matter as the application subsequently submitted to the court, and to enable the respondent meaningfully to respond to it, so that it can be established whether a response is a positive opposition to the particular claim made. The required degree of particularity must also be a question of substance, not of form. This too may also vary according to the circumstances of the case. Greater particularity may be required, for instance, if a party relies on its statements made in multilateral fora. Thus, in the Marshall Islands cases, the court found that no dispute could be inferred from a statement made by the applicant in a multilateral setting, given that statement's very general content and the context in which it was made. Even greater care may be needed if reliance is placed not on a party's statements in multilateral fora, but on its voting record on resolutions. The court has noted that a state's vote on a resolution is not of itself indicative of its position on every proposition in the resolution, let alone of the existence of a legal dispute between it and a particular other state. Myanmar's written pleadings thus give examples of General Assembly resolutions which state in general language that there have been violations and abuses of human rights in a particular state, and which call upon that state to end immediately all violations of international law. Resolutions such as these, as a matter of form, specifically allege violations of international law by a particular state. However, in substance, they are insufficiently precise to establish that a legal claim is being made by any given state voting in favour of the resolution against the state that is the subject of the resolution. The latter's silence in the face of such a resolution would not mean that there is a legal dispute between it and every state voting for the resolution. Another context where greater particularity is needed is the case of statements by a state which itself is not specifically affected by breaches of international law referred to in its statement. A state that is not itself specially affected may well express a view that a state that is involved in the situation has breached norms of international law, including norms of an erga omnes or erga omnes partes character. But in the absence of a sufficiently clearly expressed intention, it cannot be assumed that the non-specially affected state is thereby asserting a specific legal claim of its own, much less assumed what that legal claim might be. To demonstrate this point, the written pleadings give the further examples of a motion of the Canadian House of Commons and a statement of the Canadian Minister of Foreign Affairs. Like the General Assembly resolutions I have referred to, these are political statements, not legal claims. In short, this fourth requirement is inherently necessary and is reflected in existing jurisprudence. Madam President, members of the Court, I turn then to the circumstances of this case. The focus in this case is on a note verbale sent by the Gambia to Myanmar on 11 October 2019 and Myanmar's lack of response thereto. The Gambia also relies on various other prior resolutions, statements and silences preceding this note verbale, but these other matters are addressed comprehensively in the written pleadings, and I need deal with them only briefly today. None of these other matters, singly or collectively, could conceivably establish the existence of a dispute between the Gambia and Myanmar concerning alleged breaches of the Genocide Convention. First, the Gambia relies on certain declarations and resolutions of the OIC. None of these are statements by the Gambia, much less statements of the executive government of the Gambia. None of them clearly alleges that Myanmar bears state responsibility for a breach of the Genocide Convention. Indeed, the last of these OIC documents, adopted by the OIC's supreme organ in May 2019, calls for a case to be brought before this court on behalf of the OIC, yet contains no reference to genocide at all. While we now know that the OIC committee envisaged as early as February 2019 that this case would be brought under the Genocide Convention, this was not known to Myanmar at the time and was not apparent from a reading of these OIC documents. Secondly, the Gambia relies on reports of the United Nations Fact-Finding Mission, the FFM. These FFM reports are not statements by the Gambia, and there's nothing to suggest that the FFM was authorised to speak on behalf of the Gambia or was purporting to do so. Thirdly, the Gambia relies on two statements made by the Gambia at the General Assembly, neither of which contains any reference to the Genocide Convention and neither of which is addressed to Myanmar. Fourthly, the Gambia relies on silences by Myanmar in the face of an OIC resolution and the FFM reports. Obviously, if the resolution and reports did not amount to legal claims by the Gambia vis-à-vis Myanmar, then Myanmar's silence was no positive opposition to any such claims. Finally, the Gambia relies on 3 statements of Myanmar, none of which mentions the Genocide Convention. None of these earlier matters establishes a dispute. We're thus left with the October 2019 Note Verbale, which is found in Volume 4 of the Preliminary Objections at Annex 121, page 850. I ask the Court to look at this 2-page document. Its brevity and vagueness are striking. What facts does it refer to? None at all. It refers generally to, quote, the findings of the UNFFM, unquote, but does not say what those findings are. It quotes an OIC resolution referring to, quote, the practice of genocide against Rohingya Muslims, unquote, again without specifying any facts. In the Note Verbale, the Gambia claims no knowledge of its own of the facts. It refers merely to the FFM reports, saying that the Gambia is, quote, deeply troubled, unquote, by these. It finds the FFM reports to be, quote, well supported by the evidence and highly credible, unquote, but with no suggestion that the Gambia had access to or could itself evaluate the FFM's evidence. It refers generally to, quote, related resolutions, unquote, of the OIC, without specifying which resolutions, apart from one that it quotes. It refers to Myanmar's, quote, denial, unquote, without specifying the statements said to constitute such denials. As to norms of international law, it refers generally to, quote, the Genocide Convention and customary international law, unquote, or to, quote, international law and human rights covenants, unquote. It does not specify which conventions it refers to, other than the Genocide Convention, or which norms of customary international law, or which provisions of the Genocide Convention. Ultimately, there is not even any positive allegation of the Gambia's own that Myanmar is in breach of international law. Having referred to the FFM report and the OIC resolutions, the final paragraph of the Note Verbale simply says that the Gambia, quote, understands, unquote, Myanmar to be in breach of international law. That final paragraph then ends with a hortatory call for Myanmar to comply with its obligations, reflecting a similar call in an OIC resolution that it quotes. In short, the language of this document is similar to that in the General Assembly resolutions or the motion of the Canadian House of Commons and statement of the Canadian Foreign Minister, which I have given as examples of documents that are not legal claims. Having considered the terms, I then asked the Court to consider the context in which this Note Verbale was sent. At the time it was sent, 8 months had elapsed since the OIC committee proposed bringing this case. At the time it was sent, 7 and 4 months had elapsed respectively since the OIC Council of Foreign Ministers and Islamic Summit had resolved that this case should be brought on behalf of the OIC. 3 months had already elapsed since the Gambia agreed to be the applicant state. 2 weeks had elapsed since the Gambia had announced to the General Assembly that it would lead concerted efforts to bring this court case on behalf of the OIC. And a week had already passed since the Gambia instructed its legal representatives in this case. This was not a case where there was first a dispute between the parties, followed by a decision of one of them to submit the dispute to the court. What happened here was the reverse. First, a decision was taken to bring this case before the court. Only months later did the Gambia then take steps to generate the necessary dispute. At the time it was decided to bring this case, the purpose for doing so was not to settle a dispute, as there was at the time no dispute. The decision to bring this case was therefore not for the purpose for which the court's contentious jurisdiction is made available to states, namely dispute settlement. For that reason alone, the application must be inadmissible. 3 further points about the circumstances should be noted. First, there were no prior bilateral dealings between the parties against which this note verbale could be read and understood. The Gambia had been engaging for months with the OIC and its other member states on preparations for this case, but not with Myanmar. For Myanmar, these were the Gambia's opening words on the matter. Secondly, if the note verbale had wanted to make a specific legal claim on behalf of the Gambia against Myanmar, it could easily have done so. At the time it was sent, months had passed since the decision to bring this case, and the Gambia's legal representatives had already been appointed. Shortly after the note verbale was sent, the Gambia submitted its application instituting proceedings, which does identify specific acts and specific provisions of the Genocide Convention said to be breached. It seems it was a conscious choice to send so brief a note verbale. Thirdly, the note verbale contains no reference to the intention to bring this court case. Now, there may well be no general requirement for an applicant to give advance notice of such an intention to a respondent. But given that here the intention had existed for months, the failure to mention it is striking. This suggests, if anything, that the note verbale is not yet making a specific legal claim by the Gambia. Given the wording and the circumstances of this document, should Myanmar at the time have understood it as making a specific legal claim calling for a response? It was a 2-page note from a state not specially affected and not directly involved in events, and which had not previously engaged with Myanmar in relation to the matter. It specified no facts and was vague and general about the legal norms said to be violated. It contained no reference to potential court proceedings or to the Gambia's role in the OIC initiative. It merely referred to what was stated in FFM reports and OIC resolutions and called upon Myanmar in a general way to comply with its legal obligations. No specific legal claim was made that Myanmar could meaningfully take a position on. This was not a document that called for a response. Indeed, the note verbale itself does not even request a response or imply that one was expected. Furthermore, even if a response was called for, quod non, It cannot be said that a response was called for within a month. It had taken 8 months from the OIC committee proposal for the Gambia to send these 2 pages. How can Myanmar reasonably have been required to respond to such broad and unparticularised claims within 1 month, especially when the Gambia indicated no time frame for an expected response? The inference can be drawn that the Gambia expected no response. At the time the note verbale was sent, the Gambia presumably already knew that it would submit its application exactly a month later on 11 November 2019. The intention from the outset was presumably that the note verbale, containing references to breaches by Myanmar of international law and the expected lack of any response to it within a month, would establish the existence of the necessary dispute. However, there was no dispute in substance, and that is what is required. The note verbale was so general and lacking in specificity that it is not possible to determine that it was making any legal claim at all, or if so, exactly what legal claim. It identified no facts and made unspecified references to human rights covenants and customary international law. It is impossible to determine whether its wording had in mind all of the matters subsequently included in the application. It could have expressly stated that the Gambia was making a legal claim against Myanmar, but it did not. It did not call for a response, but even if it did not call for a response within a month. Therefore, even if it did advance a legal claim, quod non, no positive opposition can be inferred from Myanmar's failure to respond to it by 11 November 2019. For these reasons, the requirement of a prior dispute is not met. Madam President, members of the Court, that concludes my presentation on the 4th preliminary objection and brings to an end Myanmar's first round of oral arguments. I thank you for your kind attention.
I thank Mr. Staker, whose statement brings this sitting to a close. The oral proceedings in the case will resume on Wednesday, 23 February 2022 at 1:30 p.m., when the Gambia will present its first round of arguments. The sitting is adjourned.